All right, everyone, I think we're ready to get started. My name is Will Brantley. I'm the president of the Federal Society at the University of Virginia. And on behalf of the chapter, I'd like to welcome you all to our second annual symposium. So, building on last year's focus on the critiques and disagreements within the originalist jurisprudence, this year's symposium, Originalism, Precedent, Exploring the Paths to Reform, will consider the intersection of originalism jurisprudence and stare decisis. With the ideological composition of the Supreme Court swinging to a reliable, conservative majority, the court will be increasingly faced with deciding whether stare decisis binds the court overhearing past precedents. The symposium will explore how originalism and stare decisis guide the court to decide some of the most pressing legal issues of the day, reforming the administrative state, and religious freedom. We are grateful to the Dean's Office, IT, Building Services, the Printing Center, Communications, and Media Relations, and our dedicated and exceptional faculty who supported organizing and participating in the symposium. We are grateful for the generosity and encouragement of the National Federal Society. And we would also like to thank the Journal of Law and Politics for co-sponsoring the symposium. I would like to also especially thank TJ Whittle, our symposium chair, for all of his hard work and dedication in organizing the symposium. I can attest, as his roommate, that he has spent many late nights and long days planning and organizing the symposium, which I think not only speaks to his dedication to UVA's FedSoc chapter, but also to the originalist legal movement as a whole. I would also like to thank Killian Wyatt for creating our beautiful brochures, posters, and social media. Connor Crandall, our VP for Special Events, for arranging catering, the live streaming of this event, and very importantly, the closing reception. And Rachel Daly, our VP for Speakers, for coordinating logistics, room reservations, and all of our hard work over the last year. I'd also like to thank Matt Hoke, Drew McKenzie, our symposium deputy chairs for all their hard work over the semester, and all the members of the executive board of the Federal Society of the University of Virginia. I hope this symposium leaves you to consider the approach the Supreme Court will take in revisiting precedent as it charts a new course. And if this new course will be more faithful to the true meaning of the text when the Constitution was adopted. And with that, I'd like to introduce our first speaker, Professor Josh Blackman. Professor Blackman is an associate professor of law at South Texas College of Law in Houston. Professor Blackman specializes in constitutional law, the United States Supreme Court, and the intersection of law and technology. Professor Blackman has authored 3 books, most recently, Introduction to Constitutional Law, 100 Supreme Court Cases that everyone should know. He is an adjunct scholar at the Cato Institute. Professor Blackman is the author of 4 dozen law review articles, and his commentaries appeared in the New York Times, the Wall Street Journal, the Washington Post, and many other national publications. Today, first, Professor Blackman will explain the lower court can be originalist, and second, we will also discuss how the lower court judge and apply originalist precedents. Thank you, Mr. Blackman.
Thank you so much. It's a pleasure to be here at UVA. My first time speaking at UVA. I'm glad I finally remedied that absence on my resume. Also, to Will and TJ and everyone else, this is impressive. Most law schools can't put on a conference like this. Most law reviews can't put on a conference like this. A FedSoc chapter put on this conference. Kudos to you. And I cannot think of a more important and timely topic than originalism and stare decisis. My remarks here are based on an article I published recently in the NYU Journal of Law and Liberty. Google it, but I will give it to you now live. The tension between originalism and stare decisis is well known. Many of the Supreme Court's most significant decisions are completely unmoored from the original public meaning of the Constitution. Now, a Supreme Court justice may recognize that a given precedent is non-originalist, but followed anyway because of stare decisis. Or a Supreme Court justice, let's call him Justice Thomas maybe, may decide to deviate from stare decisis because that precedent is non-originalist. The unique status of the Supreme Court, perched at the top of our judiciary, gives its members leeway to make either decision. Lower court judges, however, do not have that sort of discretion. Consider a judge on the Federal Circuit Court of Appeals. She's bound by Supreme Court precedent to bring the Constitution, regardless of whether those precedents are originalist or not. No matter how wrong a Supreme Court case is from an originalist perspective, the precedent must be followed. Second, a circuit judge is bound by circuit precedent interpreting the Constitution, regardless of how wrong those decisions are. Generally, only an en banc court can reverse a circuit precedent, and those proceedings are increasingly rare. But an originalist circuit judge has jurisprudential free rein in a rare case of first impression, where neither the Supreme Court nor the Circuit Court has considered the constitutional question. But even then, she would still be at a comparative disadvantage. Why? Circuit courts seldom receive the wealth of originalist briefing that are directed at the Supreme Court. Here, the circuit judge wants to do his or her own research, law office history as they call it, without the benefit of the adversarial process. In short, it's tough for a lower court judge to be a constitutional originalist, but it can be done. The first part of my talk today will explain when a lower court judge can be an originalist. And the second part of my talk will explain how a lower court judge can be an originalist. Let's start with the basic premise. When can a judge be an originalist? We have to acknowledge that originalism operates differently on the Supreme Court and in the lower courts. The justices are constrained but not bound by stare decisis and can reverse non-originalist precedent. Circuit judges are bound by Supreme Court precedent, no matter how flawed those cases are. Lower court judges will have free rein, perhaps when there's a case of first impression and when there's no circuit precedent on point. But those are rare. But I think there are still cases where lower court judges have discretion. And I want to point to a recent decision called Garza versus Idaho. Justices Thomas and Gorsuch wrote a separate opinion, as they often do nowadays, giving a framework. And they wrote that if there is, quote, little evidence suggesting that certain precedents are correct as an original matter, the court should tread carefully before extending our precedents in that area. Lower court judges maybe can't follow this in its entirety, but I think what lower court judges can do is decline to extend a constitutional rule to brand new circumstances if the precedent itself is unmoored from the Constitution's original public meaning. Okay? So let's start with some basic principles. We often see in judicial confirmation hearings that lower court judges are asked about stare decisis. And the question usually takes a form like this. Was Brown versus the Board of Education correctly decided? Right? And we all know what that question is getting at. The follow-up is, was Roe v. Wade correctly decided? Right? Because the second you anchor yourself and say, of course Brown was correct, then why can't you answer Roe? And then we all know what the follow-up there is. Will you vote to overrule Roe? Right? It's what every single nominee for the last 50 years has basically been asked at any hearing. Right? Senators want to know, will you overrule a precedent I like? And it's not just Roe. I think that Republican senators want to know, will you overrule a case like Heller, the the Second Amendment decision. Or would you overrule Citizens United, which is a campaign finance decision? Now, nominees are smart. They know what to do. They have these things called murder boards where they prepare to answer these questions. And they give what I might call a rope-a-dope, where they sort of dodge the question, they bob, they weave, they do everything they can to avoid going after them. Right? What's the rule? I cannot talk about any case, the so-called Ginsburg rule. But I think there might be a different way to ask these questions. Right? Lower court judges cannot overrule precedent. I think it's the wrong question to ask them. I think the better question to ask these judges is, will you extend a given precedent? I'll point to the recent hearing of Professor Naomi Rao, who was my professor at law school at George Mason. I'm a big fan. And she had a little bit of a bump during her hearing. I don't think it was ultimately fatal, but it was a little bit of a bump. With Senator Hawley, who also is a former colleague of mine, also another law professor, former law professor at least. And he said, here's his test, right? He thinks Roe is wrong, he'll say he's a politician. He thinks that substantive due process is a myth, he can say that he's a politician. But he said, quote, I'm not going to vote for any nominee who would expand substantive due process. Expand. He says, lower court judges are, of course, bound by Supreme Court precedents, including the bad ones. I agree with that. They don't have any choice. But anyone willing to expand substantive due process will not have my support for the federal bench. Now, I disagree with Hawley's tactics for a lot of reasons, but I think he honed in an important point. Rather than asking nominees, will you overrule precedent, they can't say that. Right? Roe might have led to assisted suicide. Roe might have led to a right to same-sex marriage. Right? It was the extension that judges have control over. They can't undo the past. And this is where Justice Thomas and Gorsuch can come in Garza versus Idaho. Now, you may have never heard of this case, but I think it's important. This was a Sixth Amendment ineffective assistance case. You might know that the leading precedent is a case called Strickland versus Washington. Our entire Sixth Amendment jurisprudence is basically a fiction of the Warren Court. Not exactly, but it's not grounded in any sort of original meaning, right? You have a right to a lawyer, but the government doesn't have to pay for it, right? And if the lawyer was bad, that didn't mean your conviction's overturned. This is a modern doctrine in every regard. I think if Justice Thomas had his way, he could probably overrule Strickland. But he didn't go that road, right? In this case, Garza, Justice Thomas and Gorsuch acknowledge that Strickland and his progeny don't discuss the original meaning at all. And I think on that point, they're emphatically correct. And he says, Strickland's created a lot of deviations from original meaning. But then he makes a point that's worth stressing. He says, because there's little available evidence to suggest that Strickland is correct as an original matter, the court should tread carefully before extending our precedents in that area. Right? So Thomas and Gorsuch were not calling on the court to overrule Strickland. Right? That would be, I think, a huge shift in our polity. What he says is, let's limit it. Right? Let's cabin our ineffective jurisprudence to where it's been before, but not extend it to new circumstances we've not considered. Right? If you think back to torch as one else, remember if you have a row of townhouses that are on fire, right? And you want to blow up the one in the middle to prevent the one at the end from burning. I do it the same way, right? We have these precedents. They're wrong. They're poorly reasoned. Let them stand by themselves and don't go to the next one. Or as my colleague Randy Barnett would say, this far but no farther. Sorry, Kurt. I made 20 minutes of mentioning Randy. Don't go beyond them. I think that Garza gives a framework that lower court judges can employ to decide a case that implicates non-originalist precedents. And I think this tweak can actually work well. If there's a Supreme Court precedent that is unequivocally wrong as an original matter, lower court should tread carefully before extending that precedent to a novel context. I think you can operationalize this in three ways. First, a circuit court judge should determine. Sorry, I just jumped. Okay. First, a circuit court judge should determine whether a given precedent is completely unmoored from the Constitution. This standard should be deferential. I know we can always pick at any decision, say, they were not original, so they don't pass my purity test. You have to be a little better. right? So even a case like New York Times versus Sullivan, which established this actual malice standard, Blackman pretty much made that up. But I think at a minimum, there's some precedent going back to the founding that the Sedition Acts were unconstitutional, and we should maybe have a different standard to punish government criticism, right? I think I'm okay with that as a general matter, right? So is this something that was made up out of whole cloth, completely without any mooring in the text of the Constitution, right? The second thing that a circuit judge consider, does this case require an extension of a non-originalist precedent, right? And this is actually easier than it sounds. Very often, litigants will go to court saying, Your Honor, I recognize current precedent doesn't support my case, but I'd like to extend to this new circumstance. In those cases, that's easy, right? The plaintiffs are asking for it, maybe the government's asking for a new rule. But there's some cases where it's not where it's a closer call, where the party says, well, Your Honor, I think this is governed by precedent. The other side says, no, this is an extension. If it's even a mixed bag, it's not an extension. I'm going to be very, very deferential to this rule, right? But then comes the third question, right? Once you acknowledge that a precedent is non-originalist, and once you recognize that the parties are asking for an extension, I think in this narrow lane, an originalist judge has some latitude. An originalist judge could say, this is a novel claim. It's not governed by Supreme Court precedent. As a federal circuit judge, I have a duty to the Constitution. And I ask myself this question. Does the original meaning of the Constitution support the extension to this new claim? And if the answer is no, then the extension is not made. If the answer is yes, then you make the extension. So the narrow realm where my thesis works is they're trying to do something new that's not been done before. And you can't simply say, well, I'm going to just follow the trajectory of the Supreme Court. You don't have to. You can. But there's a narrow claim where you don't have to. Now, some people may object and say, Josh, that's unfair, right? Some litigant somewhere will lose a constitutional remedy if the lower court sticks to the original meaning of the Constitution. But that purported unfairness is premised on an important assumption, that judges have a general power to develop constitutional law to promote fairness. I don't think that's right. In some cases, the law promotes fairness. In other cases, quote Dickens, the law is an ass. And very often, the Constitution doesn't lead to fun results. When possible, originalist judges should restore the correct, even the unpopular meaning of the Constitution. And they can do so by following the Garza framework. Okay, so I think that's the when can original judges be originals. The second one actually I think is more difficult, and that's the how. In an ideal world, all advocates would develop originalist arguments in all constitutional cases. Even progressives who are generally skeptical about originalism would fine-tune their briefs to persuade originalist judges to cross that divide. I think we're seeing now groups are creating what they call Gorsuch briefs to maybe put Justice Gorsuch's play in criminal procedure cases, which I think is a very smart move. That strategy makes sense at the Supreme Court, where there are only a few votes in play. But given the current status quo, advocates in the lower courts are unlikely to invest the time and resources needed to generate meaningful original arguments. Lawyers bill, you'll know this very soon, right? You can't go on every single tangent. You have a client who's paying your fees. More often than not, originals briefing may not be worth it. At the Supreme Court, all the high-profile cases attract a phalanx of originals amicus briefs on both sides of the aisle. In the lower courts, originals friends are far and few between. But I think that lower court judges can remedy this deficiency. How? They can request supplemental briefing to determine whether a given Supreme Court precedent is supported by original meaning and whether that precedent should be extended. Even if the parties don't brief on their own, judges can always ask for supplemental briefing. These requests can be made on an ad hoc basis, which has value, or a standing order. As the court establishes, if you are arguing for an extension of precedent, give me some history, give me some originalism. Either way, judges can ensure that originalism is tested through the adversarial process. And through this process, judges can ensure that their originalist opinions are the highest quality and persuasiveness. So let's start. Here's what we don't want to happen. Right? One of the most common criticisms of originalism is the law office history charge. And it's not a trivial charge. Legal historians think that lawyers have no business engaging in legal history. They think that's not our rule. That we're lawyers, we should stick to our lane. And I think that's a misnomer. People like Kurt Lash, Prakash, people have done really good historical work on the Constitution's meaning. I think it's a myth to dismiss them, but you have to take the charge seriously. People like Sy and Kirk can devote their careers to this. Judges have limited time. And when judges and even law clerks try to decide a single case on their own, they can make mistakes. Right? When you try to, in the span of a month, learn about the original meaning of a provision of the Constitution, you're probably going to screw up. Now, there are ways to remedy this, right? One way, sorry, Kurt, is original boot camps, right? My colleague Randy offers a seminar on originalism at Georgetown. You should all apply, consider doing it. If many of you are clerking, you bring a skill set to your chamber that your judge may benefit from immensely. I think students should always apply to this. But even then, right, even if the law clerks are trained in this sort of methodology, you still have the potential for errors, right? Especially if you're writing a dissent, you might never get another judge's input, right? It's just you. And I think a sloppy originalist decision is worse than no originalist decision at all, right? I think you actually set the movement backwards by doing it poorly. So it has to be done right. And believe you me, any Thomas opinion, any Gorsuch opinion are going to be scrutinized with a fine-tooth comb to find even the slightest error because they want to nail them. Our standard is higher. Our standard is perfection. Right? Usually all originalists, we're held to a perfect standard. Ask the other side what their standard is for a living constitution. Oh, we just this and that. It's all nice, right? Everyone gets happy. But with ours, there's actually criteria to judge it by, which is good. You can assess if it's right or wrong. And you have to be damn good. Damn good. So the first proposal I have in the short term is that court should request originalist briefing on an ad hoc basis. Consider a hypothetical case. The plaintiff asks the court to recognize the Sixth Amendment violation, whatever it is, doesn't matter. The panel can then ask the parties to brief how that extension of precedent is justified by the original public understanding of the Constitution. Ideally, this request will be made at the outset of the appeal, when the initial scheduling order is issued. Indeed, judges and law clerks can screen cases for possible originalist issues that warrant supplemental briefing. This orderly process ensures that the parties have adequate time to address these issues, and counsel will be prepared to argue and answer any originalist questions during the oral argument. Critically, you have originals on both sides of the V. The plaintiff can criticize the defendant's history, and the defendant can criticize the plaintiff's history. All members of the court will be presented with a full airing of the issues. That's good. Now, there may be cases where the court says that the briefing is inadequate. Because look, most attorneys aren't trained in this mode of thinking. At that point, the court can appoint an amicus in front of the court to brief a specific issue. That person can be a professor, maybe, or it could be a scholar, or it could be a private practice attorney who has an expertise. But you want to ensure that the court hears all arguments. I don't think anyone can object to that. Maybe they'll say it's a waste of time, but I think having more arguments is always better than having fewer. We have some practice here. Recently, the Sixth Circuit heard a case. It involved a fairly obscure habeas corpus issue, which I don't feel like boring you with now. But at the outset of the case, the three-judge panel, Judges Seiler, Thapar, and Judge Hood, issued an order, supplemental briefing. And I'll read you the order. It's very short. The first question: what is the original meaning of the Article 3 case or controversies requirement? And then they said, how does corpus linguistics help to inform that determination? Imagine that, right? How does the original meaning relate to the distinction between holding and dictum? The party shall file briefs within 21 days, not to exceed 25 pages. That's pretty straightforward, right? Now, the opening rounds of briefs didn't address any of these questions. And I think it would have been unfair for the court to decide these issues without the briefing. So the court wisely asked for supplements after oral argument. Now, the responses, I think, are worth discussing. DOJ filed a thorough brief. They studied the BYU Corpus of Founding Euro-American English, the COFIA, which is the gold standard for corpus linguistic studies. And they said that the corpus confirms its reading of cases or controversies, and it goes to the history. The petitioner, the other side, filed a brief that was candid, and it said that this brief has limited utility, right? We don't think corpus helps very much. Okay, they were candid. Perhaps not the smartest argument, but they were candid. Ultimately, the panel decided the case, and they said, we don't need to touch this right now. So it kind of fizzled out. So I don't want to use the end result as what should always be. But the fact that the court requested the briefing in the manner they did, I think, was significant. But I have a problem with sort of ad hoc briefing. The problem is this. It's ad hoc. And only certain panels request it, others won't. I think that sends a very bad message. Only some judges care about this stuff and others don't. So I think a far smarter approach would be a standing order. Courts adopt standing orders all the time, right? And it can be simple. I propose language. You could say, in any case that implicates an extension of constitutional precedent, all party briefs shall explain how the original public meaning of the Constitution supports or forecloses that extension. And for example, amicus curiae are invited to seek leave of court to discuss how the court should interpret the Constitution. A simple order like that would put people on notice, an umbrella approach, that judges want to learn about history. That judges want to learn about the adversarial, they want to learn about this history in the adversarial process. There are no surprises, and advocates can have their arguments considered. Also, I think that amicus, right, law professors, law school clinics in particular, should have an incentive to participate. I think judges should give argument time in these cases. I think it would be better if you're 3L, write a brief, get 5 minutes of argument time. That'd be pretty cool. But at bottom, this is something that judges can drive, right? Judges can drive this even if lawyers and attorneys don't. And one of the upshots of this approach is not everyone's persuaded by history, but when you're presented with it, you have to respond to it. For example, in Heller, Justice Scalia wrote this 100-page original decision. What did Justice Stevens do? Did he go living constitutional? No. He had his own history. And when you fight on that ground, you've won the war, right? And once you get to the point where the majority of the dissent are battling about which original's argument is better, I'll take that. I will take that any day as a victory. And I think that if the appellate record and the circuit courts have more history, it becomes easier for the Supreme Court to do this. It's not they're not considering it in the abstract. They have a record below where this has been vetted. Now, it is entirely feasible that this process convinces a judge that original is not helpful. I get that. I understand that. That's entirely possible. But the framework that I propose leaves open the possibility that originalism can be useful to decide these questions. Okay? Now, my focus so far has been on judges. But I think that judges who adopt this framework can exert market pressures on the bench and on the bar to become more familiar with originalism. Law firms who seek to persuade originalist judges will rationally incorporate originalist arguments into their briefs, whether voluntarily or in response to an order from the court. Public defenders, in particular, will be well served to refine their arguments. Conservative jurists may be personally opposed to the plight of the accused, but favor the rights of the accused as originally understood. But this briefing should not be cobbled together haphazardly. Practicing attorneys of all stripes will need to improve their ability to develop originalist arguments. In an ideal world, law firms will begin to recruit associates who have originalist bona fides. And, dare I dream, law schools may recognize these market forces and begin to offer courses on originalism taught by originalists, self-professed originalists. Imagine that. Perhaps law schools will establish originalism clinics. Generally, once an issue is briefed in one court, the same briefing will be recycled in other courts that present similar issues. A simple order from a court, a standing order, would in time trickle down to all facets of legal practice. And we have many brand new originalist judges who can maybe pick up this mantle. This change will be top down rather than bottom. Sorry, this change will not be top down, it will be bottom up. And in turn, I hope that ripple will trickle all the way to the Supreme Court. As the bench and bar are acculturated to originalism, it will become far more normal for the Supreme Court to base its constitutional decisions on originalism. That's my hope. Thank you all so much, and welcome to questions. Yes, over there.
So it seems to me that most of the story hinges on what counts as expansion precedent.
Yep.
Defer, I say, the disagreement about the extension, this kind of extension, I'll just say. But determining what counts as an extension, you've got to talk about what the principles are adopted by the precedent. And how do you think they do that? So if they do that by original, so when you sort of ask, it's an extension of the precedent. You've got to figure out what counts as a whole. And the holding is the combination of the outcomes and the rule on which it rests. In which case, you're back at it. Right now, we're disputing what principles are using to figure out what counts as a whole.
Very good. If you couldn't hear, the question is, how do you decide what's an extension? How do you decide what's a holding? I largely elide that question by saying, I'm going to limit this for the parties ask for an extension, right? Where they ask for one, there's no dispute, right? It's obvious. But there can be a lot of borderline calls. If it's even a close call in my mind, it's not extension. I think lower court judges have to put the thumb on the scale of, let's be restrained in going down Josh's road. But the question of what's a holding, what's a dictum, what's the precedent government, that's the subject of something so behemoth, which is why I don't want to touch it here. But it's a powerful question. Justice Thomas's framework in Garza, I think involved the case where everyone agreed this is something new that hadn't been done before. So I think there is a small sliver of cases where there is something novel. But I don't touch that here because I know it's a huge gorilla. Thank you. Other questions? Questions? Once? Twice? Early, huh? Okay, there you go.
Is there a role for district judges in this at all? Or how in general can a judge kind of develop to be an intellectual entrepreneur?
Ooh, I like that. So the question, if you couldn't hear it, is there a role for district court judges? Anyone clerk in the district court here? I am. I clerked for 2 years. The district court's a very different world than circuit courts. All go visit. They're nice places to visit. You don't have much time. And opinions have to be written very, very quickly. Right? Some decisions are made in the course of a trial where it's 5 minutes. I think it's going to be harder for a district court judge to engage in this activity because they're on a crunch of time. I think they can. It's very often the case nowadays that district court judges are asked to decide on really important constitutional questions on this sort of expedited basis. We want a nationwide injunction, right? Decide this in 5 seconds. And I fear that sort of rush posture forecloses intellectual entrepreneurship, to use your phrase. But I think absolutely district court judges should think about these things. Their clerks should be trained. I think all law students should have some familiarity with originalism, not just a straw man that's knocked down in 5 seconds, which is what unfortunately a lot of law students learn, but actually a coherent method. And even if you don't agree with me, right? Even if you think originalism is garbage, fine, I'm not going to fight one. Too bad. There are judges who disagree with you, right? Your job as an attorney is to present arguments that will win your client the case. And even people who think originalism is terrible will become facile with it, will become comfortable with it to avoid losing votes, right? If you need Justice Gorsuch's vote to win your case, you're not going to say, screw Scalia, this stuff doesn't matter, right? So one of the virtues of having so many new originalist judges is the market pressures. I don't say that lightly, but it does alter the way that lawyers have to approach cases involving constitutional rules. You can't just wing it and say, oh yeah, whatever, text history. Quote an 18th century dictionary, be done with it. No, there's more that you have to do. Go if you're doing something like the 14th Amendment, go look at Kurt Lash's new volume on the ratification amendments, right? If you're doing something executive power, go check Professor Prakash's work on the executive power, right? There are things that you can consider that will help you. You can't just blow it off. Yes, right there.
Do you view progressive judges using originalism for progressive goals as a growing trend? And if so, do you have any examples of that kind of reasoning?
Sure. So if you couldn't hear it, the question was about progressive judges using originalism for progressive goals. You know, I don't know if it's a trend. I think it happens in cases where there's competition. So for example, in the Second Amendment context, you see a lot of dissents about, you know, what did the framers think about gun control, right? My goodness, we just had an impeachment, feels like a year ago. The entire impeachment was, what did the framers think about abuse of power? What did the framers think? And these are people who would usually think the framers are a bunch of slaveholders who shouldn't be respected at all. But for some reason, when courts are at issue and legal issues are present, there's just this desire to go back to the framing. I think it's what Randy calls a gravitational pull. But you have this desire. So I don't know if it's a trend of progressive judges, but I'm happy to see it, right? And the reason why is I can assess an argument based on history, right? If it's an argument based on values and what people think is fair, I don't know, maybe that's right, maybe it's wrong. I can't assess it. But at least with history, I can make a qualified judgment. There's another hand over there. Yeah.
I really like your point about how being a lawyer doesn't necessarily make you an historian, that's a different kind of training. When you have issues with historicity, you have one group saying this is what the history says, and another you're saying something else. If the judge then decides this is the best originalist approach, is there a stare decisis of that historical interpretation? And
good question.
Turn that historical viewpoint to the required briefings, or
Yeah, I mean that's a good question. What if you have an originalist decision that was based on faulty history, right? In other words, does an originalist decision that's based on faulty history itself have stare decisis? From my perspective, if it's wrong, it's wrong, right? If there aren't many originalist precedents, but I'm sure some people argue Heller's one. Just assume, let's say, we uncover some lost archives that James Madison said, yeah, of course, the Second Amendment protects the right of the state militia. It's nothing that, I'm just making it. That's not really what's going to happen. But, as an original, say, wow, that's something new. We didn't know that back then. Or maybe I talk about corpus linguistics, which is something I'm spending a lot of time on. Corpus linguistics may show that dictionaries are not the best way of doing originalism. And there's a lot of work that was done using dictionaries that maybe isn't the best. For example, dictionaries plagiarize each other. Right? A lot of dictionaries, they just copy. So if you have one definition, they're all going to be the same, which is not indicative of how meaning was used. We also have linguistic shift, where maybe words are being changed over time. So I'm completely open to using the idea of originalism to second-guess precedents. In fact, I wrote a short essay on Heller. I think Scalia got some stuff wrong. He made some assumptions about the Second Amendment's text using the data available at the time. And if you use corpus linguistics, some of his assumptions don't hold up. I think Heller, at bottom, has enough history to support it, but there's some elements that aren't supported. By the way, Stevens got much more wrong. This is people say, oh God, you're jumping on Scalia. Stevens looks much worse after my analysis. But you have to admit, Scalia got some stuff wrong. And I think you have to be candid and honest about that, and it gives you a little more credibility to speak on the issue. But thank you for the question. Yes, over there.
I'm interested, so in sort of originalism, especially with the advent of new technology, how you square that with originalism, especially in areas like fourth interest groups, for example, where there's new technologies that the founders never even contemplated?
So the question, if you couldn't hear it, was on emerging technologies like the Fourth Amendment. This is not my area. Will Bode and Steve Sachs, if you want to read about Fourth Amendment originalism, I encourage you to read their work. And Orrin Kerr is kind of the opposite side. The Fourth Amendment and originalism have a very awkward relationship. And I think in terms of settled precedent, there's so much to overcome that there's not much new. Maybe you can have the framework I propose, and you just don't extend the Fourth Amendment to new circumstances. Maybe that's one approach. I haven't thought this through carefully, but it's an area where there's a lot of debate. For example, the Jones case involving GPS a couple of years ago. Justice Scalia tried to bring back the trespass theory. He tried mightily hard, and I don't think he got much support in that front. So I don't have a good answer for you, but it's a very good question. Yes, right there.
There's a lot of frustrating, especially at the Supreme Court, but among the circuit courts as well, because it's forming these opinions. So as originalists, should we be willing to compromise somewhat the quality of our originalism if we think that it advances the prayer in terms of the outcome, or should we be?
And are you asking on the circuit court or the court or Supreme Court?
Both, among the panels and then especially the Supreme Court.
Okay, so the question you can hear was about horse trading. You probably know this implicitly, you have a couple friends who want to go to a movie, and one person wants to see Star Wars, the other wants to see, Little Women, and then maybe you pick something in the middle to decide where to go, right? Very often when you're on a multi-member court, you have to make compromises, and a judge says, well, I'll be happy to join your opinion if you strike out this paragraph. Otherwise, I write a dissent. And there are collegial needs to avoid dissents. I think the approach I'm describing in this paper, honestly, is best useful for dissents or a concurrence, a solo concurrence. I think once you have to persuade others, you have to water stuff down and dilute it. And there's a risk of doing that because it looks like you're going halfway or you're doing sloppy work. Right? The opinion we see published need not be the decision that was actually drafted initially. Supreme Court decisions always have these little footnotes, but we don't mean this, we don't mean that. Here's a clarifying. And Justice Kennedy would say, well, I concur in everything except for this. I think it's useful for judges to join a majority opinion and say, but I doubt this is correct as original matter. That's saying, look, I'm down, but here are my thoughts. Supreme Court, take it up. I think that's probably the best way of doing this. Right? In other words, you join the majority opinion, the entire, not just the judgment, you join the majority opinion, but you concur saying, I think this precedent is as far afield from original meaning. I think that would be the way to do this. Yeah, in the back.
Do you think there are situations where the corpus linguistics or the history are murky or ambiguous enough that it doesn't provide enough solid footing for a judge to make an opinion on that basis? Yeah,
I mean, look, every originalist, Kurt and Sil probably back me up, will argue that at some point the text runs out. Right? At some point history runs out. There's some questions that original cannot answer. And you have things about construction, other tools, which I don't have to get into. But when you're a federal judge, you're not a professor, you have to recognize your agency. And if the Constitution doesn't get you there, at that point, in my mind, at least, you defer to democracy, which not everyone agrees with. Maybe Randy will say you defer to liberty. I don't know, right? Maybe Randy's right in some cases. But if you're an originalist judge and you got murky, and you can't make an informed decision, then you defer to the democratic process, which maybe is not a good default rule, but it's a general rule that I think can get you most of the way where you need to go. So I had some over there. Yeah, over there.
Yeah. With increasing concurrences and steps, what kind of effect do you think that would have on parties with the seat cert, and how would that likely increase? Do you think that would be a positive net effect or negative?
Well, let me answer it this way. Judges don't get paid by the hour, right? If judges are spending all their time on writing these scholarly concurrences, that means you're spending less time on deciding criminal appeals, habeas motions, prisoner petitions, civil appeals. And look, you're going to be litigants soon. You might have to wait 14 months for a decision from the circuit court. That sucks for your client. So I recognize that what I'm describing here has a cost, right? The more time you spend writing these erudite decisions, you're not doing your bread and butter appeals. So I think there's a cost there. Now, in terms of whether those separate opinions help for cert, absolutely. I think if the lower courts are vetting these issues, it becomes a lot easier to cite Judge Thapar, or cite Judge Jim Ho, or cite Judge Willett, or whoever you want to cite, Judge Holden, future clerk standing over there, right? They're very good judges, and I think, you know, if Justice Alito is looking at an Andy Oldham opinion on original, he'll take that seriously, right? If Justice Thomas is looking at a Jim Ho opinion on the Eighth Amendment, he's probably going to take a look at that really carefully. So I do think there's a trickle-up effect in many regards.
That's all.
Thank you.